Excuse me. All right, good afternoon. C 2013-2985, City of Tucson plaintiff versus Roger Randolph and Richard Miranda, defendants. This is a hearing on various, all of various motions. We'll go ahead and take the appearances, please.
Bill Risner for the plaintiff, Cecilia Cruz, who's sitting with me at council table.
Michael McCrory for the City of Tucson, and with me is Dennis McLaughlin.
All right. This hearing is being held pursuant to an order that I issued on February 17, which was very specific with regard to areas of interest. And I have quite a few questions I want to ask today. First of all, currently before the court are Ms. Cruz's memorandum regarding attorney's fees and costs and request for a what's termed as a culprit hearing. Ms. Cruz's request to amend the court's Rule 60C3 ruling and request for hearing, and Ms. Cruz's motion to amend her complaint to assert a claim for damages. In my most recent ruling prior to the February 17 order, I opened up and permitted discovery related to whether there should be additional sanctions imposed pursuant to ARS 12 section 349A, which you all have my rulings and you know what they say, but in general terms was spurred greatly by what occurred following the original sanctions order in this case, the June 4 release of documents, and then the statements and various things that occurred at a hearing in August of 2014. And I think all the lawyers are aware of that and have seen all the orders. Okay. In my February 17 order, I did say that whoever was appearing had to be prepared to discuss the record in detail, and by appearing was representing an ability to do so. Is everybody prepared to discuss the record in detail? Mr. Risner?
I'm prepared, yeah.
Mr. McCrory?
Yes, Your Honor. I may ask Mr. McLaughlin for some assistance.
Okay, I'm going to start off, Mr. McCrory. I have a lot of questions for you, so I'll start with you. And oh, by the way, I might as well tell you all the things that I've read. I've read all the briefing that has been submitted since we last got together, and I have read the entirety of Mr. Elias's, Ms. Bicat, Mr. Kaselemis depositions. And I have those depositions up here with me if somebody wants to cite me to something in case they think I'm wrong about it. But I've read them in their entirety. And I've also reviewed all of my rulings in connection with this matter. Mr. Parcel testified that emails drop off after 180 days. He testified as such on December 5 of 2013, page 25 to 27 of his deposition. Ms. Bicat said the emails drop off the system in 90 days. Which one is it?
It's both, Your Honor, depending on which one of the parts of the program you want to look at. For individual employees, everybody throughout the city, after 90 days, your email automatically disappears and is off your screen. You have no access to it. You can't retrieve it, you can't look at it, you can't obtain it. And I think that, first of all, that's very important from a public records standpoint, because the government employee or official who we're trying to examine, whose work is involved, no longer has access to any emails after 90 days. What Mr. Parslow was talking about is that the city in prior years used to maintain a system of backup tapes for catastrophic recovery. Those were not generally available to employees. They were not used by employees. They were available for the IT department in the event that there was some catastrophe for all the city's computer systems, and they had to totally restructure every part of the computer system. And so they maintained those for 180 days. They had some of those for different periods of time. They as best I understand, none of those were logged in any formal, rigorous sense. They were kept by IT, and IT would occasionally access them.
You know, this is significant, and let me address one of your arguments very early on, and I suspect you'll raise it, or we're planning to raise it. In your briefing, and I use the word your, but I realize you represent a client, but in your briefing you say, well, all of these issues have been addressed before, and all of these issues have been raised. But the record has been developed further, and I think it's perfectly appropriate to consider the record in its entirety in light of developments in the record as it has developed further. So I don't think personally that there's anything inappropriate, looking at the record as a whole, and in fact you cite the McKee case for the purpose of me. One of the propositions in that case is I should look at the record as a whole. And neither do I think it's inappropriate for the court to look at the record as a whole as it has developed in determining whether my initial sanction was sufficient under the circumstances. And so that's something I'll address right up front. Now, why I'm talking about this with the emails is there was earlier testimony or statements developed in the record, I think testimony from Mr. Parslow, that Mr. McLaughlin didn't tell IT to get involved with the search for records in connection with this matter until September, which would be significant for a couple of reasons. The most notable right off the bat is that there was a trial in July. And so that's 2 months at least after that trial. And second of all, Mr. Parslow testified about the 180-day drop-off. Ms. Becat says it's 90. If it's 90 from September, that takes it back to June, basically, that you would have dropped off on the emails. If it's 180, that takes it back to March, correct?
Correct, although actually it goes back further, and if I can explain that.
Well, I'd like you to, because I've got some specific questions about a couple of specific emails that I want to talk about.
I think first of all you have to understand the nature of the city's group-wise system at that point in time. And that's not our current system, but it is what was in effect at that time. In order for IT to complete a public records request, what they would do is the same thing that an employee would do, which is to go into the group-wise system as that employee in that employee's personal account. So they take Albert Elias, they log into Albert Elias's account. Within GroupWise, there's a search function that lets you search for emails, both sent, mailed, tasks, appointments, and you can print all those out. At least in theory, when Mr. Randolph sends out his notice of a public records request and the letter from from Ms. Cruz, that goes to all the employees. They do exactly that at the point they receive it, and that would have been early May of 2013. To immediately tell IT to do that would be, in most cases, simply duplicating exactly what the employee was supposed to be doing, who got the records request. So that's why there wasn't automatically sending it to IT. At that point, the city wasn't looking at the backup tapes. And I think when you look at the backup tapes, I want to refer to them as digital trash. Because the backup tapes, as I said, were not something the employees had access to or used in a regular course of business. It was a record that, as far as they were concerned, they had thrown away. And I think if I can use an example for the court, suppose Chris Kaselemis is sitting there the day before the public records request comes in. He gets Hector Martinez's appraisal file, which the plaintiffs have said is very important in this case. He gets an inter-office mail. With that is a cover letter. And the cover letter says, here's the enclosed appraisal report. On the cover letter is a post-it that says, here are the people I talked to within real estate in preparing this. Chris Kaselemis takes that, and with paper, what would normally have happened would be he would throw the cover letter and the post-it in the trash if he didn't need it. Because what he's interested in is the appraisal. He's now got the information where it came from. He doesn't need to keep that or retain that. And I think there's another important point here, and that is Mr. Risner's always proceeding on some sort of obligation to maintain emails. There is no obligation to maintain them in the normal course of business unless you're currently relying on them. Once you don't rely on them, you're entirely free to get rid of everything.
Let me ask you. Two things. First of all, and I was listening to every word you said, but I was thumbing around out here for a piece of paper that I have, which perhaps in the moment I couldn't locate, but I remember what it says. Correct me if I'm wrong, Mr. Kaselemis testified that the routine procedure in his original deposition back in 2013, the routine procedure for these types of things is to go to the IT department right away. Isn't that what he said?
I believe he did testify to that.
Okay, so isn't that contrary to what you just told me is the regular procedure, and doesn't that fly in the face of waiting until September?
Not necessarily, because again, if you get back to the repetitive nature of just your 90-day emails, Chris Kaselemis also testified that as soon as that came in, that public records request, he was on vacation. But Camila Beckett went into his machine and copied down what was on his machine. One of the exhibits in the deposition taken back in October.
Because she also said there was a thumb drive that she gave to Mr. McLaughlin. Does anybody know where the thumb drive is?
I believe that's been produced, the shared drive has all been produced to him back in September of 2013.
I'm sorry, Mr. McCrory, I interrupted you. Go ahead.
The exhibit that was used in the deposition was an email from that Chris Kaselemis had printed out on January of 2013, well before the 90 days or 180 days. That's clearly in the record. That email can only be found by the project study term because that's what the subject line was. And it doesn't mention Grand Canyon. So part of this is that Mr. Risner has always known from the beginning that project study was a term. But that email was produced because it was part of a hard copy or was something that Camila Beckett found at the time. So she's produced that. She also went to his emails, printed out his emails.
Well, can I stop you for a moment? That email, which you're referring to, I think, is a February 8th email by Mr. It's a February 8th email that Mr. Kaselemis would have had to print out in February, correct?
The one is, I think it's Exhibit 22 to Kaselemis' deposition. I thought it was January 22nd that was printed.
There's a February email, isn't the well, maybe there's a different one and I'm wrong. Yeah. Isn't the significance that one of the significant points related to that February email is it establishes that if you take the drop off, it establishes that that email was in the possession of the city attorney's office and was lost prior to the July 8 representation and the July 23 representation. Doesn't it? Isn't it one of the points that helps establish that?
I'm not sure which one you're referring to. The one I'm thinking of was one that was turned over, and if it's printed in February, those were all turned over in either May or June, as best I remember.
Well, but I want to come back to another point. Okay, go ahead, sir.
This isn't the 90 days or 180 days. This is where a public official or employee has printed out an email and actually made the effort to say, this is something I'm still using. Creating that as a different kind of public record than what I'm calling the digital trash, that he says, no, that can go away, I don't care about that. This is something he pulls out, Chris Kaselemis had pulled out and printed that Exhibit 22 in January of 2014. For whatever reason, he felt it was important to keep it. Those were produced. There were appointments produced. And in fact, almost every meeting, if not every meeting, was known from documents that were produced in May and June of 2013. And I haven't seen anything produced by the plaintiff saying, here in June of 2014, in that certification, here's something totally new that we've never seen before. Here's a new meeting that we haven't seen before.
Are you taking the position that if it isn't printed off and relied upon or used by the city employee, then it's not subject to a document request?
I think the city could take that position.
Well, let me, before you, and I don't do this to interrupt you and be rude, but I just do it so I remember my train of thought. There's two distinctions, isn't there? There's a distinction between what I can get rid of, and I either do and I don't get, or I don't get rid of it, or knowing that I have something when a document request comes in, and then deciding I'm going to get rid of it. Those are two very distinct situations.
That's absolutely true. I'm not dealing with that distinction at all. I'm dealing with a different distinction of when, even when a document request comes in, then Mr. Kaselemis has to get whatever is in his 90 days. To go beyond that 90 days to 180 days, that's the same thing as telling Mr. Kaselemis, okay, with that paper cover letter that came over with Mr. Martinez's file, you put that in the recycle bin. You have to now go through the recycle bin and see if there's anything you threw away that could still be retrieved that might be pertinent to this matter. It's not something he's relying on. It's not something he kept as a matter of course. I think actually there's an argument even with the 90 days, because I know a lot of employees, myself included, never delete emails. The city can take them after 90 days. But you go back more than 10, 12 days, I've never looked at those except maybe for reservations for hotels sometimes. They're not part of my work product. I don't think they're part of most work product. So I think you have a difference with electronic records, that it's easier not to throw something away than it would be in the accumulation of paper. And we're putting a different standard on that than we would put on paper. We don't ask that somebody go check the garbage or the recycle bin and say, can you find everything that you may have had on that moment that the request came in? But effectively, the city has said, so far, we are taking the broadest approach to public records we can. So we're going to go and look at these backup tapes to make sure we have found everything we can. And that's what it did. And it did that without any court order. Nobody required it to do that. And as I say, it could have had a position saying, you're not entitled to this. It could have come back and said, those are tapes on a group-wise system. Our only legal obligation is to present you with that tape, not any document. And you have to pay the expense of figuring out how you can decipher it.
Well, okay, let's stop. Let's go down that road for a moment then. I would say at this point, my conclusion is the record, including Ms. Beekat's deposition, Mr. Kaselemis' deposition, the existence of that February email that I was talking about a moment ago, strongly, if not overwhelmingly, support the conclusion that Mr. McLaughlin had received Mr. Kaselemis' hard files and lost them prior to the July 8 representation, and certainly prior to the July 23 representation at the beginning of the trial. Do you disagree with that?
I disagree with the court's conclusion from that, because there was a hard file turned over. That was produced, and there are documents.
Okay, let's stop. Now we're getting into semantics. Mr. McLaughlin has told me in a hearing that he lost 2 hard files.
Those are
those
different.
2 hard, well, no, they're not different for purposes of my question. The 2 hard files were not found, haven't been found as far as I know. And so what I want to know is, those files were lost before the July 8 representation of full response, weren't they?
No, the 2 files that were lost were after those representations and not related to those representations, and also in Chris Kaselemis' deposition. He describes that process. And what he describes was Mr. McLaughlin going down repeatedly, time and time again, to compare the documents he had previously had and produced from.
I read the
Yeah.
entire deposition. Let's come back to the two files. How do you say that, why do you contend, or what's the basis of the contention that they weren't lost before those two representations? And let's remember what those two representations were. First one was in a writing filed when Judge Lee was still assigned as the trial judge to this case before I took it over, or at least I think, no, actually I would have had it by then, but you all might not have known that by then. It was in a motion. It said we have fully responded to the request. Didn't include anything like, well, you know what, there are these tapes in storage somewhere. We're not obligated to give them to you. They do exist. If you want to argue about whether we're obligated to give them to you, then we can have that argument. Judge can decide whether we are or we aren't. Just said we have fully responded. It is, I've put it in 3 or 4 different rulings. It is an unequivocal assertion of a full response. It cannot be read reasonably as anything other than a full response. Then, you've got, with the exception of those 7 documents, approximately 7 documents. Then on July 23, we have a trial. Beginning of the trial, I'm told, Mr. Risner has 4 witnesses here from the city. There's no need for testimony. We got the 7 documents you need to look at, and I'm obviously paraphrasing. There's only 7 documents. You can look at it in camera. There's no need for anybody to take testimony. Why wouldn't I be told at that point, well, you know, there are actually tapes. They do contain emails. We do not believe we are required to produce those.
I think there are a couple of reasons, Your Honor. Part of it's just practical, is how many people deal with those tapes. I think part of it is also, I think the court is looking at it through a certain lens presented by the plaintiff, that representation on July 8th was everything, we've produced everything we ever going to produce. We are done, we're out of here. So there's no other issue to try about that, because we've completed everything we're giving you. And that's the way the court has read it and repeated it numerous times. I asked the court to consider a different perspective. And consider the perspective of the city saying, we have fully responded, we're only testing these narrow issues. On the other requests and issues raised, of whether or not you get meetings, whether or not you get appointments, whether or not you get notes, whether or not you get whoever's different documents, we're not contesting those. It should not have been in the past tense to say we fully responded, but it is quite accurate to say, out of all the potential issues in this case, we're responding to those, we're not responding to the narrow ones of the attorney issue and the negotiation. Now, where that really makes sense is if you carry through after those representations to what the city did. If in fact the city's position was in July, at the hearing and in that motion, that we are not looking for anything more, we're not turning anything more over, we're done, nothing else would have been produced, we would not have 2 years of litigation. We have this litigation because the city never meant that it was stopping looking. And that's clear from Kaselemis' deposition that Mr. McLaughlin continued to look repeatedly. In that process, the city discovered more records. It didn't seek to fight disclosure of those, it produced them. It produced them in August, it produced them in September, produced the full shared drive which already duplicated things again in September. It then went in October and December and recreated digital trash. That process took over 2 weeks of an employee's time, setting aside all other city work, where he had to spend it just on this public records request to recreate something that essentially no government employee would ever rely upon. That is not the demonstration of an attempt to conceal anything. It is not the demonstration of we are at the end of this process. It is absolutely evidence that the city always intended to find as many documents as it could. And in fact, the only order out of this court prior to May of 2014 was with respect to those narrow 2 areas of documents, disclosing the negotiations and not disclosing attorney-client. There never was an order, go back and keep looking and keep finding and keep producing. And yet the city did that on its own.
Let me ask you though, weren't these great productions though in close time relation to when Ms. Cruz continues to litigate? Are you taking the position that 800 pages would have been delivered on October 25 regardless of whether or not there was a hearing on October 28?
Absolutely.
And you're taking the position that the June 14, 204 documents previously undisclosed, 130 of them which existed back in May of 2013, that would have been produced had Ms. Cruz not brought her motions in the spring of 2014?
I think I want to address the June certification one later.
Well, I'd like to know, are you taking the position that you would have produced that regardless of whether she brought her motion or not? That seems like a pretty simple question.
I don't believe we would have produced that one. And the reason is because a lot of the impetus of doing that was the plaintiff's focus in May of 2014 and the court's focus on you haven't looked for project study in that digital trash bin. You used Grand Canyon and GCU as your search terms, but you never used project study.
Correct me if I'm wrong, I never mentioned using project study in my ruling related to the original sanctions and requiring the June 4 certification. The use of project study, and I could be wrong, I know the record pretty well.
I could be too.
But I don't think I ever brought up the term project study with regard to your actions until after the June 4 response.
It was based on project study, but I have to take back the part of, I think the court's right that it was a later time that came up.
Okay, let me ask you, while we're on that subject, and we've used some time, I want to move along. I actually have a hearing that, this is set for an hour, but we've got a 2:45, so we do have 45, 47 minutes here. There is a January 29, 2013 email. Exhibit 9 to Ms. Bcat's deposition. It says, let's not use Grand Canyon, but use project study. That's in that email. And she talks about project study documents at page 38 of her deposition. I am still at a loss, notwithstanding your explanation in the briefing, how that term couldn't have been used to search until 2014. And second of all, regardless of whether I accept the statements about the computer system being different, I'm certainly no expert on computer systems. It still begs the question why 204 previously undisclosed documents, 130 of which existed in May of 2013, weren't produced. Mr. McLaughlin had previously told me, I think in October, but I could be wrong, I don't have that right in front of me, October of 2013, after the 800 production. We've pretty much done it all now. If there's anything more, essentially it's going to be here or there another document. That's pure paraphrase, essentially a trickle of documents. Okay, so how, number one, why wasn't project study used to search? Which is a question Mr. McLaughlin, who's been responsible for this the whole time, and was the only lawyer working on this the whole time, and was also responsible for accumulating the documents, couldn't answer at my last hearing, where I asked the question. And even if project study was somehow different under the computer system as it exists today as opposed to earlier, why those 204 documents escape detection and production?
Okay, first on the project study issue, it was something that Camila Beckett first looked at when she went in May to look through Chris Kaselemis' documents, and that's exactly why you have documents in May of 2013 that are produced that have project study as the only identifying term. So that was used as a term to search at that time. What was not used as a term when Mr. McLaughlin went to IT and had them recreate post offices for the digital trash. And in going through that process, prior to doing the search, there was letters back and forth with the plaintiff's attorney. They said, we want to see all your emails about the search. And then there was an argument whether they were attorney-client, and then Mr. McLaughlin said, okay, here they are. And the emails had the search terms being used. They had a train of emails in which Mr. McLaughlin at first suggested to IT that they search for Grand Canyon, VCU, and Project Study. IT fought back and said, we don't want to do all three. The reason they don't want to do all three is that they're looking at the amount of time they have to spend. They had to spend over 2 weeks already on just 2 terms. That's exponentially higher on the 3rd term.
Who works for whom?
The IT works for the city.
Okay.
But there are also other things that the city is doing besides spending an entire 3 weeks on one individual's public records request for what's trash.
I guess I keep coming back, Mr. McCrory. I still haven't heard a real explanation.
I didn't get to finish.
Okay,
Yeah.
I'll let you finish. But actually, before I do that, I want to come back to where we were, then I'll let you do that. When were those 2 files lost?
Those are lost sometime, I believe, in September.
Why wasn't I told that?
I don't know.
Because here's how,
But
every one of us sitting here who's a member of the bar, and I don't know, maybe people out in the gallery are members of the bar. Every one of us sitting here has been a member of the bar a long time. I might be the most recent member of the bar, and I'm in my 29th year. So it's been a long time, all right? When you tell a judge you have fully responded to something, and then you tell a judge a second time you have fully responded to something, both times qualifying it with these 7 documents, and then it turns out you lose files, don't you think you ought to tell the judge, you know, Judge, we might have been wrong about that, we lost the files? I mean, to be really blunt, I am pretty slow to anger, and I'm pretty skeptical of sometimes, you know, one of the things I try to do is not jump to conclusions about the veracity of members of the bar or their clients. It's not something that I do easily, and I don't automatically jump on board when somebody makes an accusation. When I look at this entire record, I have a really difficult time with the distinct possibility that there's been a lack of candor to the tribunal in 2 respects. Number 1, those 2 representations, early and subsequent representation. And number 2, not correcting them. When, you know, we all practice law, we all know when something doesn't get produced that should have been produced and we'd said something, come back and you say, you know, Your Honor, when I stood up and said that, I thought that was absolutely right. Turned out it wasn't. This is what I found out. I corrected, and I want to make sure the record is clear. I want to come back to the fact those files, based on the testimony, certainly appear to have been in Mr. McLaughlin's possession before July. And you're taking the position there weren't?
I think if you read through that carefully, part of it is we're doing it now 2 years ago. And Mr. Risner was doing his best to confuse Mr. Kaselemis on the dates by quoting from different parts of another deposition out of context at various times. So I think there's some suspicion about that. I think if you read it, though, he talks about he keeps going back to the fact that Dennis McLaughlin came repeatedly down to his office.
I read that.
The other thing that was critical about that is he said they kept examining and seeing all the documents were produced except for some that were irrelevant. Those are the ones that were in the missing 5, were the ones that were irrelevant. Everything else had been produced, and there's no indication that those irrelevant documents would have any effect on this case. And there's also nothing to indicate that there is anything that has in any way obscured transparency of government in the loss of those files, which actually is about 1 or 2 pieces of paper.
When was well, I'm looking at a May 10, 2013 email from the mayor. Actually, it's from Mr. Kaselemis to the mayor. You've probably seen it attached to a briefing here.
I'm not sure which one you're referring to, Your Honor.
The mayor just responds, sounds good, enjoy your time off, etc. The mayor doesn't say anything in detail. He says, see you when you get back. Mr. Kaselemis goes into detail, and it's not a flattering email. It's an email that isn't flattering. It talks about various projects. It talks about this project. It talks about somebody named Chuck H., who I can speculate who Chuck H. is, wanting to be getting into the project and being very upset that he's not in the project. And it's dated May 10, 2013, but apparently, according to Mr. Risner, it wasn't produced until December. What, would that be irrelevant?
If that is produced in December, then it is part of going back and restructuring post offices to get digital trash. Something that Mr. Kaselemis had no access to, didn't use, had thrown away at the time. So that's not a public record. We could have made that case, but we're trying to be more proactive in terms of providing everything we can, so that we've gone back and to recover those things and not worry about whether it's not flattering or not, but produce it.
Okay, now there's testimony that calendars are public records.
That's correct.
I struggle to see why somebody's calendar would be a public record in the eyes of the city, and an email wouldn't, to be honest with you. But let me ask you this. Have the calendars been produced?
The calendar information has been produced. What has not been produced...
is the actual slides of the calendars, correct?
That's correct.
All right. And when the July 8 representation was made and the July 23 representation was made, then the city knew that the calendars had not been produced, correct?
No, because there had been already, there were at least 3 appointments that had been produced in May and June. And those documents were produced, and those are appointment documents. To the extent Mr. McLaughlin had information, the files he got, there weren't other documents provided that were appointments. The calendars exist as a screen view, not as substantive information. The digital information is all in emails. So when emails are produced saying, here's an appointment, here's the time, the date, the place, the subject, that is the digital information supporting the calendar view. And in fact, producing that produces more information than you get in the calendar view, which doesn't include a lot of that. It just says, here's your appointment, half of what the subject is.
Let me come back to, if your position is that the overwhelming majority of things that Ms. Cruz has sought, B, received, aren't anything the city would have had to produce in the first place, why'd you do it right before hearings? And second of all, why not simply say to her, you know what, this is what you're entitled to, you're not entitled to anything else, and that serves the other purpose. It puts it right in front of me, and I can decide whether I agree with you or not. Wouldn't that be the approach to take?
We may well take the latter approach in all future litigation and really restrict access. But no, the city's position at that point and its approach to it was to say, we're going to try and get as much as you can. For the timing of it, I think if you also look at the timing, every time the city has proactively provided something, that's immediately followed by the plaintiff saying, this is evidence they're bad. So you go a little more time. Now, it takes more time to do this. The city's still pursuing additional information. It comes up with more. The time for that earlier motion is now coming for a hearing. You have not once had Mr. Risner trying to cooperate with the city and work with them. You've had, on the other hand, the city go way out of its way to produce things. And one example of that's the whole issue of the appraisal, because that's been raised by Mr. Risner throughout this litigation. I have had those appraisal records. That was actually a public records request to Hector Martinez. He's not a defendant here. That's technically not part of the case. It was produced early on. There was a one-page sheet that was produced. That sheet showed some terms of sale. It was produced with a letter explaining what it was. It was later produced in digital format with the metadata. And twice during that time, two or three times, Mr. Risner keeps coming back. He doesn't go back to the city and say anything, but he says, see, they produced something I didn't have, or see, I don't have something.
Okay, now I've read the transcripts, and I've seen that Mr. Risner, on behalf of his client, conducted an expansive questioning of witnesses concerning subjects which at least you argued, and in some instances might be the case, weren't really the scope of the deposition. For example, he's explored documents that apparently don't exist, something of a non-hypothetical appraisal, although I guess there's some argument that all appraisals should be hypothetical, shouldn't be non-hypothetical, or I may be messing that up, but that a policy related to appraisals was not followed. That's not really what we're deciding. That there was no analysis of the value of El Rio to the community, which sounds to me like a subjective analysis as to what the population, or maybe a poll, which wouldn't be subjective, it would be objective as to what people thought El Rio's value to the community was. And that there were no writings related to the price analysis that's set forth in the city manager letter, which was produced earlier. So I've seen there's been a lot of discussion about documents. I guess the point is, still come back to, why wasn't it just simply said, you know, we're not going to do this. This exists. These things exist, like a privilege law. We have these tapes. We have these things. We have emails, like an unflattering email right here. It's unflattering. I'm not going to say the person's name because they're not really in the litigation. They're, I think, a city employee whose name hasn't come up, and it's just not a terribly nice thing that's said about her in the email, so I'm not going to say her name on the record. But why weren't these things simply disclosed, their existence disclosed, and said, no, we're not going to produce them. It's beyond the scope of a document request. It's not a public document. It's irrelevant, etc.
There was no point in time in which all this information was known. Again, we have to go back to the nature of Mr. Risner's practice in this case, which is demanding, first of all, on May 13th, I need every document you have in 4 days. And then immediately claiming when it wasn't produced in 4 days, see, the city's trying to conceal and hide everything. When some information is produced, well, now you haven't produced everything. Now I have to file a lawsuit. Now I've got to do this. Each time he has sought to attack the city rather than find out any information. On the appraisals, the city set up a meeting with the city's appraiser and the outside appraiser. That's way beyond what public records requires. But it wants to try, it has always had its policy to try and be as transparent as possible. The stuff on the backup tapes, nobody knew what was in those prior to their being produced and copied. You know, nobody could say, yes, that one that you referred to is produced in December until that post office is restructured. Nobody remembered what that was, and nobody was keeping it as their own file. So nobody could say, we're not going to produce that, because they didn't know it. When the city did take those extra steps, and again, without any court orders, it found those and then disclosed them. And I don't know what else the city could have done. I mean, other than come in and say, look, yeah, we're going to start fighting all this public records. We're not going to produce any of these. Maybe that would have been the better course, but the city has tried to be as open and transparent as it can, realizing that one of the things in this is that after May 28th, this is no longer an issue for anybody in the city because it's off the table. Whatever happened, happened prior to May 28th.
Isn't actually, there's two sides to that sword, so to speak. I have not ruled, and none of my rulings have said that the city has to produce evidence or documents related to ongoing negotiations, and there would be all sorts of reasons why you wouldn't do that. Okay. The example was given back in the original trial that the U of A, when discussing the High Corbett Field lease related to the baseball team, was very concerned that that not be made public until the matter was completed. And the city took the position in the original trial in this matter that you don't give up information concerning ongoing negotiations. That makes perfect sense. And but by the time we had the trial, it was all done. But it sounds to me like you're saying, well, now since it's all done, it's irrelevant, even though relevance has nothing to do with a document request.
No, I'm sorry, Your Honor, and perhaps I misspoke, but I wasn't, or you misunderstood me. I wasn't going to go to the point that it was irrelevant. I was going to the time period to produce it, that you're asking employees who have a lot of other things they have to do to take time out to go back and get that information. For those employees, you were asking why didn't these things come forward sooner?
Why is it any different if let me just pick, if a city department is sued for negligence in a significant tort case, death case? And you all have that happen sometimes, sadly, but it does happen. You have to go find every document that exists. In fact, you have to disclose it under Rule 26.1 unless it's privileged. You have to go find it. Why is this any different than that?
I think first of all because there would be some limits on that. There'd be a lot of limits on ESI, the electronically stored information. I don't think those would cover the digital trash without extensive court proceedings as to both the relevancy and the need for them. It would not cover metadata without court proceedings. It would also provide substantially longer time to find those and time to collect those. Plus, it's also a very discrete event that you can usually isolate, although you continue to have supplemental disclosures, and that's the responsibility to have supplemental disclosures. The city in this case essentially was following a similar pattern. Here's what we have for the basic information. And so far I've never heard anything from the plaintiffs saying, I didn't know enough in May and June to know what was going on with that. So we tried to get the basic stuff out, but then kept going and trying to find, can we find every single piece of information? Can we go back to people?
Can you think of reasons, sir, why it would be advantageous to have the information trickle out or not come out until some prolonged period had passed?
That's what I meant by after the 28th of May. It's not going to affect that deal because that deal was gone and what the plaintiffs were concerned with. There was still negotiation on something else. To the extent they want a history of that, I don't think until December is unreasonable. Particularly when you're considering you may take 2, 3, 4 weeks of time for employees to do that. I don't think that would be unreasonable to argue in an ESI provision in a court case to say we need this. I don't think it would be unreasonable to ask for sharing a cost of that. But those things weren't done. So I don't think it was unreasonable to say we're going to take some time to do that and trickling it out. And I don't think there's any evidence that that was intentionally done to prevent the plaintiffs from learning about the basic facts of what had happened.
Look, I have no idea. You know.
I would like just...
well, let me, I'll give you what do you want to tell me, Mr. McCord?
I want to give the court 2 exhibits on the July 6th, or the June 6th certification.
June 6th, be July 8th.
June 4th.
June 4th.
Get my dates fixed up here.
I'd like to talk to you about McKee in a moment.
Okay. The first exhibit is the drive of the CD that was given for these voluminous documents.
Let me stop you for a second. Mr. Safer? Yes. I'm guessing you're going to be 3 o'clock. Is that going to be an issue for you?
It's not an issue for me. I'm here until it ends.
All right. I'm just the way this is unwinding, I don't want you to sit back there unless you want to. You're obviously, it's public courtroom, but I'm guessing it's going to be 3 o'clock instead of 2:45.
And no problem. I appreciate that, Judge. I'm anticipating other appearances.
And you might, I think Ms. Darcy filed something. You might want, if you have her phone number, you might want to tell her it's probably going to be 3 o'clock also. All right. Thank you.
And Following the first one, first page, actually 2 pages, is a listing of all the files that were there. The subsequent pages are the files that were within those files. So if you go to first page, you see Albert Elias's name at the top. So there was a file produced on Albert Elias. If you go to the 3rd page, and you can see, well, that's Andrew Greenhill, but you'll see that's an individual file on the 3rd page. And up in that address location, it indicates it's Andrew Greenhill's file. And that shows what was in his individual, in that bigger file. This is the subfolder. And it shows there were duplicate measures, production from June, and then 1, 2, 3, 4, 5, 6 previously produced series of emails, and then March, no response. And I'll tell you that in some of the ones, even where they had a response, there weren't any documents. So that most of the production was previously produced. Within what was new to produce, I think it's important to understand why we have continued references to numerous documents being produced. These I selected from Camila Beckett's folder. And in these, I've highlighted what is the new email. And if you go to the first one, the basic part of the email from Yvonne Espinino was produced a long time ago. That's all. They've had that for a long time. What was added was Nicole's response, and then a response from Camilla. I will let Andy know. The point is that a lot of these are the type of cover letter superfluous information. So that when you talk about hundreds of documents, that's not necessarily hundreds of pieces of new information.
All right, I'm sorry. Mr. McCrory, are you done talking about 1 and 2?
Yes.
All right.
What?
Want to make it A and B? All right.
Okay.
A and B are admitted. Let's talk about McKee. You brought up McKee, cited it. I've already alluded to it. It's McKee versus Peoria Unified School District. It's a Division I case out of last year. McKee supports looking at the entire record in evaluating whether promptness has occurred. And I don't think there's any dispute about that. But is McKee helpful to you? Because the critical thing in McKee that struck me was the entire response was done in 24 days.
And I don't recall the details of what that response was, or how many pages, or how many departments or individuals that were involved in that.
Well, McKee involved a drowning at a high school PE class. And Mr. McKee, I believe, was the teacher who was being terminated in connection with the drowning. And he had a public document request concerning various different categories. And I think that the district thought they had responded within 16 days, but then on the 24th day, I believe, I could be wrong on this, right before the eve of his hearing, they came up with a handful of notes that they hadn't had before, and they turned them over. There was one other document that was contested, and I think Division I ultimately concluded it was really a document created by the Glendale Police Department and not by the school district, and that Mr. McKee had a document all along anyway. And Division I said, no, you gotta look at the whole record with regard to promptness, and they reversed a $67,000 fee. That's my understanding of McKee. But in the end, doesn't that, how is it? You're producing 200 documents that weren't produced, and you're producing them on June 4, which is more than a year after Ms. Cruz's request. That's a little different than 24 days, isn't it?
Again, Your Honor, a couple of things. First, going back to that exhibit that I just gave you, Exhibit B, it's not fair to say they're not produced. these are documents where one of them had 6 emails. That's 6 new documents produced. If you take the last of that email, that has every other one of those included. But you've now multiplied it by 6 because you can pull out each individual recipient's part of the train. The information on that was basically given much earlier. That what we're giving is supplemental information. Some of them are like, thanks, I got your report. So to say that that there are 240 documents, I think is misleading in terms of what content we're dealing with, and it certainly doesn't address transparency in government to say a secretary said thanks, or a secretary sent an appointment and then got back thanks, or any of those things that could be in there. I think the other part about McKee is, in terms of looking at the whole record, this court entered an order for sanctions. The issue the court raised in its order, at least as I understood it, was, is there anything after that that should merit additional sanctions? And that's why we've said there's a narrow time frame that the court really was looking at in that order. Not because you don't ever look at the full record in any case, but because this court had looked at the record, had dealt with that and issued sanctions that it felt were appropriate. So then it was, where do we go from here, based on those depositions?
What if I were to conclude that the record as it exists now supports the conclusion there's been a lack of candor to the tribunal? Do I not look at the whole record in determining that, in determining the appropriate 349 sanctions?
I guess I'm having a little trouble with the court saying at this point we're going to go back and revisit everything, including all my prior conclusions, based on an order in which I said I want to look at what happened in June, and I want to have depositions about those, and I want to see what the information from those depositions is.
Well, see, I think those depositions reveal that those files were lost prior to the July representation and prior to the July 23 representation, and that the calendars hadn't been produced prior to July 8 and July 23, and that those facts should have been told to me. And now you think the record doesn't support that.
That's correct, Your Honor. And I think, again, it does go back to the point that it was an ongoing process. Appointments had been produced. That is absolutely clear.
Mr. Risner, I've got several questions for you on a couple of points, but I'd like to give you a few minutes to respond to what Mr. McCrory said.
Yes, Judge, thank you. There's so much. Let me, sometimes the freshest thing that was just said is on the front of my mind, and there is a point that I want to make. There's 1 and 2 of this hearing, posts 1 and 2.
Thank you.
So the first one is, Mr. McCrory has said that that they've given us the calendar. And of course, it was much later in the case where we have gotten some thing that would say there's a meeting coming up. Number 1 says, we're going to have a meeting. And then the second document shows what's actually available on the calendar, which is who attended that meeting, who was aware, who's part of this whole process. So when he says that we've gotten the calendars, we absolutely have not. I believe that one sheet I've given you is the only one like that. But now that I've got that off my head, I want to step back to what the entire record shows. What really happened in this case is it's clear from the record that, for instance, when back in February, when the Arizona Republic asked for the same stuff, that request immediately did go to IT. It went to the departments. They knew about it. Elias said he knew about it. Those people knew that they should be saving information from that time period. Bud Foster's request was more or less the same time period as my client.
It was the day before, if I'm not mistaken.
Yeah, and the council likes, he talks about Mr. Risner's practice and what Mr. Risner did. Well, my client wrote alone her public record request. She came to me when they gave her nothing. And what did she ask for? She who had worked in the manager's office, knew their procedures, said she wanted to come in and look to see what was important. She gave them a week to come in. They've got these files. She knows how the office works. Let her do it. They gave her nothing. They didn't let her look or give her any information or any reason for it. That's why I sent a letter and said, look, she's come to me, you've given her nothing, you're required to turn over the records and let's stop this thing. And they give her very few records, and then of course we filed a lawsuit to get them. But what we've learned from for instance, Ms. BCAT was helpful in that we had the records that immediately the city clerk's office sends it through the normal procedures to the city manager's office. In her case, however, they did not send it to IT. I don't know why, but hers is the only one. The KOLD, Arizona Republic, was sent to immediately to IT by the clerk's office. But those individuals accumulated those records. The ones in the office that have that job in the city manager's office, the city, they get the records together. Then the city attorney says, stop the process. We're taking over the accumulation. They stepped into the city role. And the city attorney got everything, according to BCAT, that she put on a thumb drive. They had access to everything. The city attorney's got access to everything. And look at what was, very little was turned over when the city told this court that they had turned over all the documents. And, you know, all that they were required to turn over. Counsel says, well, but surely Ms. Cruz knew that wasn't everything. True, surely she knew. Make assertions when they say they've turned over everything. That protective order was granted before my time to file an opposition. And
I didn't grant that protective order.
No, I understand you didn't, but I'm just telling you how they use the court. And you know, this we only learned recently about and only some about the roles of the other individuals. Let me see, I've got an email. This one marked as 3. If I could show you. So this is Nicole Ewing Gavin.
Now, can we see what it is?
Yeah, you have it. Oh, yeah, excuse me. I'm sorry, Mike.
Do you have another one?
Yep, take a look, see if it's not the first one on your list, is it?
Oh, okay.
Yeah.
I thought this was one exhibit.
Okay, you got it? Yeah. You know, we learned, and one of the things that, you know, my client's not concerned, and we've not been concerned about when the secretary says thanks, when somebody says their thanks. What she's wanted to know is who was involved with this deal, who's behind it, what was the structure of it. That core still has not been turned. We know nothing about that core. Here
Wait a
is...
minute, you had testimony from, I think, Mr. Elias, that Trio met with the mayor and the city manager, and then the city manager and/or the mayor told Mr. Elias to start the process moving. Isn't that something in the deposition I just read?
Yeah, sure.
Okay.
Okay, yeah.
That's information. I mean, I don't know who outranks the mayor and who outranks the city manager. My limited understanding of city government is probably nobody, but.
Yeah, certainly.
Okay.
But the principals on this project were Nicole Ewing Gavin. She reports directly to manager, to Miranda as the assistant city attorney. She briefed the mayor on the project. She's the person here that says, hello, EIT, this is my last day heading on vacation. I'm leaving the Grand Canyon University proposal and related papers I had on Kelly's table. We have nothing from Nicole Ewing Gavin about her role in this thing. There's no hard file turned over. The papers that she talks about, who knows what that is? Kelly Gottschalk, the assistant city manager, finance, budget person that was in on this thing from the meetings, no file on her. None of that stuff. Andy Squire, his role, you see his name here all over the place. We just recently, and through the deposition, learned what the role is of some of these people. We don't have his documents. We don't have his calendar. Liz Miller, we don't have that information.
Does the statute entitle you to receive the documents or to question everybody about their role in the transaction?
It entitles us to receive the documents. But the problem we have, and the problem we have here, is that the city lied. The city is concealing. And how do we penetrate that they're concealing? We can't even ask individuals, what did you turn over, when, and who did you give it to? Because they have created a situation where they say, we're moving the lawyer in. You know, I've referred to him as Lamont Cranston. There used to be an old program when I was a kid called The Shadow, because he could suddenly be invisible. He could be in a room and nobody could see him. You know, he wasn't there. So Mr. McLaughlin is doing what a clerk does. Mr. McLaughlin is saying, show me all this stuff. Albert Elias says, yes, I gave this to Mr. McLaughlin. I believe I gave him my calendar. He had all this information. You ask, and they objected, Mr. McCrory objected. What did Mr. McLaughlin ask you? A person who's accumulating the documents. It's attorney-client privilege. So what they've done in this case is they have, this court, every stage, I mean, I hate to say it, but they've used, they cut off the deposition of the defendants who were personally, cut that off because they said we've given them everything. Then later, they cut it off. We're allowed to do a 30B6 where they object throughout that process, but we find out about information at that time, and then and Kaselemis talks about his hard copy file. That was in November, so in December suddenly, for the first time, Mr. McLaughlin says, oh, I have have lost those files. And there is no way, realistically, to read a situation where Mr. McLaughlin is sitting there and saying, let me see, I want to make sure, is this everything you have? Is this everything you have? Yeah, gosh, that's exactly the same as what's in my file. We both have the same. Let me take yours, and boom, and then they both disappeared. This whole process is a situation where they decided we're not going to give out information. If we have to lie to the court, if we have to lie to the plaintiff, we aren't going to give it to them. We're going to deep six this stuff. We're going to stall this stuff. We're going to then come in later and claim that it all disappeared, that we have this system, and blah, blah, and we were going to do this, and sure, we were going to, every time we were going to keep looking, ha, 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 keep looking. You know? They've not played fair at any point, and they have obstructed at every point. And what's the result been? Well, you know, finally, Your Honor said, I'm going to tell them to turn everything over. And that's when I filed something before, and I said, look, this is a late day, but I think there's a bit of conceit going on, because I don't think that they'll even to the court, even to the direct order, that they would turn over all that stuff. And they haven't. They haven't turned over the calendar information. What have they turned over of Nicole's, of Kelly's, of Andy's, of those key people that we know were involved at key roles in the process? And what we're asked to do is accept their story, except that he says, we talked to these people and they didn't have any files. We talked to this person and they don't put anything in writing. Well, we sent you something that said somebody was, there was a meeting coming up, and if you look at the other, I've got other exhibits there of meeting notices, he claims, which are the emails, and it'll say one person, sometime, ... We don't know who else was invited, who attended, what went on, what happened to the documents, all because absolutely from the beginning. And I can't imagine a case where it is clear, where the lawyer himself has accumulated all of those documents, who had the thumb files, who had stuff, who when he talked to Albert Elias or something, went out, yeah, I gave it to him. I made it all available to him. And then comes into court and says, you know, it's all done. Protect us, we've done. And then at the end of the case, when they convince this court to enter an order which says Ms. Cruz doesn't get her costs back, doesn't get her fees back because the city's been fair. They turned everything over, and these are what all the documents. And every stage afterwards, the city says, yeah, we won. You didn't bring up bad faith in trial. You didn't know how better. You didn't do that. Later on, yep, sure, that's old news. That's old story. You lied. This is a horrendous case, and one of the biggest problems is this is a situation, and one of the reasons that I think you should permit us to find out what really went on here is because this is exemplary of the city's approach to these cases. They utilize the attorney-client privilege to accumulate documents and don't turn them over, and something happens to them. We need to know what happened here, and we need to know from the individuals that were key people. We didn't know who the key players were before. We learned some of that stuff in that short deposition. And those questions about things like the...
Mr. Risner, in fairness, you told me you wanted you only needed short depositions of certain people, and I let you propose them.
Well, I gave you a list of 11 or 12.
I don't believe you gave me a list of 11 or 12, but in any event, I believe you told me you needed only to get them under oath for a little while and then be enough.
Well, and you know what? I think I was right, because that was enough. It was enough to show who were the key people involved. It was enough to show that they were cooperative with the city. And, you know, it's, you would ask about the questions about the appraisal. Well, look, the city, and one of the things that's important here, the city has certain rules that are followed, that what you do every time. And it's certainly fair when we know the rules and we know what documents should be there, then to ask, well, is this document there? Is that one there? Because that's the process. There are documents there, and I was permitted to ask about documents that should be available, because the rules are that they should be available.
And they say they don't exist.
Huh?
And they say some of them do not exist.
They've done that, and those answers, I have to accept those answers.
Well, I don't know, they may or may not be true, but.
That's right.
In any event, that's what you were told, so, okay. I do need to ask you a couple of questions about something else, and I want to get to it. You've got a claim for damages, you've moved to amend your complaint.
Yeah.
Your claim for damages in paragraph 11 that you wish to add to your complaint is conclusory. It just says she suffered extensive damages.
Right.
I'm familiar with, obviously, Rule 15A standard for amending pleadings and the liberality with which courts should view those requests. But I'm also familiar with a couple of other concepts. One is futility, and one is that conclusory statements don't have to be accepted as true. And to simply say she suffered damages is a conclusory statement. What I'd like to know is, what is the nature of the damages claim?
Well,
is it something different than costs?
yes, absolutely.
All right. And then if it is, because the statute 1239-12102 provides for an award of costs and fees if somebody substantially prevails. And under the Ford case, that's a discretionary award, and the statute uses discretionary language. Subsection C, however, talks about a cause of action for damages. And so damages can't be costs and fees, because that would make it redundant when you read the whole statute. It would also abrogate the discretion contained in the statute. So I want to know what the nature of the damages is.
Well, you know, this has taken essentially 2 years out of my client's life to follow what was given to it. It's taken a huge amount of time because, you know, you heard the lawyers say that they shouldn't pay me to look through all these documents to make sure I know everything. Tremendous amount of time that has taken time away from her family, work, and other things. It's been a very difficult burden on her. It's been a burden on her for, you know, some political stuff. But the big thing is is all of the time that she's had to put in because of the city not producing, not letting her see things, not following the rules. Everything they've done wrong has cost her a huge amount of
Have you
time.
served a notice of claim pursuant to 12-8-2101 in connection with the damage claim?
No, I have not. You know, I think that this cause of action arose during the case itself, that the statute says she can claim damages. It doesn't say when. I'm absolutely certain in this case that, for instance, were she to wait till after the case, they absolutely would be arguing that it had to be raised during the case. And during the case, the extent of the time and the extent of the city's duplicity has become more evident as time goes by. So I don't think because this occurred within the context of the case that she's required to file a notice of claim within this case.
Okay, let me finish, and then I'll let you finish.
Yeah.
You have asserted relation back in your reply memorandum.
Right.
Relation back is a concept that relates to statutes of limitation. I'll look at it again but I'm not convinced that relation back obviates the need for compliance in a damages claim with the notice of claim statute, which requires, I mean, I know you're an accomplished plaintiff's lawyer, so you know what the notice of claim statute requires. But the statute also contemplates a separate cause of action, and you haven't told me when your damages action accrues, so I'm not finding that you were foreclosed on the basis of the notice of claim statute. I'm just wondering whether amendment at this time isn't futile because there hasn't been compliance with the notice of claim requirement.
Well, I would say this. If this court finds that this sort of conduct by the city is something that a claim is required for, and that we can bring a separate claim after the end of this case, we very much would accept that. You know, I don't think that's the case, because there's no doubt in my mind the city would be in saying, you can't make this claim and you can't file this lawsuit.
They're already saying it now.
Yes.
So.
Right, they certainly would then, but if this court says, I think you need to file a notice of claim, we'd file a notice of claim and we'll file a separate lawsuit because it has in fact damaged my client greatly. She's done everything absolutely proper. She went in, gave them extra time, asked simply to come in to see records, file a lawsuit. We gave them a couple months to come up with the records, and during that time they did accumulate everything, and they told her it had all been turned over. It's absolutely horrendous. So,
why do you think there's been the delay? Since you're ascribing to them intentional misconduct, why do you think that's the case?
Why is it the miscase?
Yeah, why? I mean, you are ascribing to the City of Tucson and to Mr. McLaughlin and to others intentional misconduct.
Yeah.
And I assume that a lawyer of your experience doesn't do that lightly, so why don't you tell me why you think that's the case?
This proposal to sell the only public land ever sold was a massive crime in progress. The land is worth probably $75 million to $100 million. They had an appraisal where the city, Mr. Elias at the meeting, one of the exhibits here, where they need to arrive at the price at the highest level. Elias and Gottschalk are at a meeting. They decide in his handwriting $3 to $4.50 a square foot.
Okay, I read that.
The next day, then the Kaselemis goes to the office of the city real estate guy and says, we need an appraisal. The city has a process. They don't follow it. The appraiser is told, here's and we have the handwritten notes as to what comps to look at. And they said, we suggest you look at a comp that's $3.50, something like that. And it comes back and they pick the lowest value. And not only do they pick the lowest value, when you do the numbers ultimately, the city has a rule you can't offer a lease more than 5 years. And in 5 years, there's $7.3 million in taxes that aren't going to be paid. They offer a 50-year lease, which is $73 million plus in taxes that won't be paid. This property, the city, at the same time, they say we want a value for just plain dirt. There's pages of documents where the city says to grant, it's the greatest stuff ever. This more than 114 acres, but 101 they wanted to sell, is more than downtown Tucson itself. It's a tremendous piece of property. The school was going to use for their buildings maybe 8 acres, maybe 20 would be the most. And yet this was a whole 100-acre thing. It was a tremendous real estate development of a tremendously valuable piece of property, and the city cooperated in seeing that false information came in when they hired a woman in Phoenix to give certain numbers on how many students and would those live in dorms. She candidly said the records showed that there are very few students living there.
That's it, this BCAT's deposition thing.
Well, I'm not sure. I think Kaselemis went into that originally.
But the number was changed.
Yeah, and the city says, and then she come back, she says, look, I'm changing it from 20% to 80% land. That's a big number, and that changes the numbers. And and I'm doing it on these other facts. When you look at everything down the line, all of those things, I look at the whole record and see what's there. And what's there was a massive violation of public policy. What's there was a huge heist in progress by individuals, each of whom has been promoted since then. And what's the roles of public people and public records? It's fair. It's a fair role. It's our system that we get to look at these things and find out who was doing what, what's going on in terms of the public business. That's what's gone on in this case. That's why they're hiding. That's why the city attorney stepped in to get these records and to deep sex them. And they played the system like a harp. You asked the question, that's the answer.
No, I asked the question, you gave it to me.
Okay.
All right, one more thing.
Yeah.
And I'm going to come back to Mr. McCrory. In one of the briefings, it might have been, I can't remember which one, it doesn't really matter. You used the word abet. This court was led to abet in fraud. We're not social friends, but you and I know, in fact, we've been opponents before in litigation, and we've known each other for some time. And so I know that you speak with passion and you represent your clients with passion. I'm just going to tell you right now, don't ever use the word abet in a sentence involving this court again in a briefing, okay? Are we clear? Are we all right on that?
Yeah, no, we're clear, and I think...
because that's a word that has criminal implications, and I don't think you're accusing me of being, corrupt or a criminal, because if I thought you were doing that, we'd be talking about it a lot more.
Look, Judge, I have high regard for you, and I apologize if you took that meaning from it. The problem that I face is that if I have to go to an appellate court, they'll sometimes say, well, if you had this problem, why didn't you bring it up to the lower court?
Okay.
The problem I'm bringing up is that they have used the court and abused the court. When they lied and said, we've turned everything over, the court says, here's the city attorney says they fully complied. So it makes sense there shouldn't be a deposition.
Okay.
When they come into court and says we've done it, it makes sense.
All right, as far as I'm concerned, it's water under the bridge. So
Okay.
let's Mr. McCrory, I'd like to give you a couple minutes to close. I do have to come back to, I am still really struggling with candor to the tribunal when you look at this whole record. And I don't know whether you want to address that. I'm even looking at an objection that was made. And the reason I'm bringing this up is I don't want to ambush anybody. Okay, I don't want to sit here and have this very pleasant hearing and then issue a written ruling, which is much harsher than the commentary during the hearing. And I don't think that I've been sugarcoating anything this afternoon. So just so we're clear. Neither does should that be read as forecasting any particular ruling either. Don't read anything into this or conclude that I've reached an opinion about something. Finally, a final opinion. On April 1, Mr. Risner that whether, I believe you take the position in your briefing, Mr. McCrory, that the city's response, whatever it was, Mr. McLaughlin couldn't have known what it was during the hearing, or during the hearings when he made the comment that he made about how we didn't respond, and they didn't file an action. But I went back and I looked at the transcripts of this process, and I looked back on April 1, Mr. Risner was making an oral argument. It wasn't even taking testimony. And on page 20, he said, the city provided no information to the largest newspaper in Arizona, just like they provided no information to the key information to our client. Then Mr. McLaughlin stood up and objected and said, Your Honor, I object. There's no foundation for that statement. There's nothing that he said that indicated we gave no information to Mr. Podesky. 4 months later in this courtroom, Mr. McLaughlin, unless I misunderstood him, said that they never responded to KOLD, or they never responded to the Arizona Republic. Isn't that objection a tacit representation that what Mr. Risner was saying had was not true, when in fact they didn't respond, y'all didn't respond? I mean, I have to tell you, when I didn't notice that the first time through, but I went through and read that transcript the second time, and that jumped out at me as something that I'm really surprised an experienced lawyer would do, especially the lawyer that's been handling the thing the whole time. So, Mr. McCrory?
I think, Your Honor, first of all, with respect to the KLD and the Arizona Republic request, the foundation objection, I think, is first of all appropriate because that's not part of this case and we're not litigating that case, so we don't have all the facts. I don't know what Mr. McLaughlin knew at that point in time versus what he knew later as to what had happened with that. I've heard Mr. Risner say it was sent to IT right away, but since we're not trying that case, we don't actually have any evidence of that, and we don't have any evidence that IT did anything.
Well, but we do have Mr. McLaughlin telling me in August that he was the only lawyer in the city attorney's office who handled document production requests. That he was the only lawyer in the city attorney's office who had anything to do with the Grand Canyon El Rio document production requests. And then telling me, with regard to those two media requests, we didn't respond, they never filed an action, which I concluded strongly indicated that one had to be willing to litigate to the mat in order to obtain a meaningful response. If anybody would know whether the city responded or not, wouldn't Mr. McLaughlin know?
Your Honor, not necessarily, and I want to go back to one of the court's comments earlier about trying not to jump to conclusions. And I would really ask the court to try and view this from a different perspective. And just taking that statement, and I'm not exactly sure what the precise statement was, but there are any number of ways that might have been resolved without having it to go to court and still get them the information they wanted. We don't know that they weren't given an interview with one of the people involved. And they said, oh, that's fine, that'll take care of mine. And Mr. McLaughlin may be the only attorney, but there are other people who deal with public records requests in the city itself. Roger Randolph's the clerk, who is technically sued here as the individual. He initially processes them. And I'll come back to that because I think there was a misstatement by Mr. Risner. And Mr. McLaughlin is telling the court as frankly as he can. If he's trying to hide things, he would have, I think, done a much better job, and he certainly wouldn't have had this continuing trickling out of stuff, or voluntarily producing all these things. He certainly, if this was all intentional, could have said, oh, I'm going to wait until after the hearing, because I don't want this to be misinterpreted. There are any number of things you can say, and I want to go back to that July 8th, and I want the court to just put yourself in a position of thinking in terms of a case and an argument that you know you've got more things you got to get out there, but you're focusing on what are the issues in terms of what type of public record is there. We're only contesting two issues as to type of public record, as to category of what we're producing. And I think the court will understand from both its role as a judge and during litigation, you sometimes focus more narrowly, and you may view things a way that, in retrospect, could have been much broader. I think what happened was that all parties were looking at what's the issue of these two. Okay, we're not going to contest whether the others have to be produced. I read the July 23 transcript. I didn't see anything, and I didn't read it carefully in full detail, so I don't know. But I didn't see anything where there was an active discussion on, is there going to be any more production? If that issue never comes in, then the parties are talking in a different context. They're talking in a context about these two issues versus the other types of categories. When you take that later out of context, it may seem a lot more certain than it did at the time. And I again go back to, why would the city then immediately turn around and start producing more things? Why would they keep going out to people, making repeated visits? As Mr. Kaselemis testified, that on up through September, Dennis kept coming down and double checking. The reason he gave him a file was because he was so tired of having coming down look at the same thing. Now, Mr. Risner's done a great job for YouTube of saying this was concealing, hiding, conspiracy. Where is any proof that a document was concealed? Where is a proof that Kelly Gottschalk had notes that she concealed? Now, I admit that he may not get that, and we may not ever know that. But it's a lot different to sit there and say all this is lies and concealing and actually proving it, and he hasn't done that. I think also I want to make sure the court goes back to the nature of this action against two individuals in their individual capacity, and that's Richard Miranda and Roger Randall. Mr. Risner said earlier that, oh, the clerk's responsible for all these records. No, he's not. And if you look at the emails that went from the clerk's office, he says, I'm not responsible for these records. Here's the public records request. So I don't know.
The statute says that he can sue them. Statute says he can sue them.
I understand that. And he could have sued the city, but he chose not to. He chose to sue Roger Randolph. Well, then he has to show what Roger Randolph did deserving sanctions. Then he has to show what Richard Miranda did deserving sanctions. Not the city, not Hector Martinez, Chris Kaselemis, or Albert Elias. What did those two individuals do? And the court went back to this issue once before, when there was an issue of agency, and it did point out that in their individual capacities, there was no evidence showing that Mr. Kasachik was speaking as their agent. And I think the same issue runs all through this. The city has gone beyond what it had to do in terms of producing things, and as much as it could as a city, not as Richard Miranda or as Roger Randolph. But the case, when it comes back down to it, is one against individuals in their individual, not their official capacity, their individual capacity. That's what he said, and that's what the case is. So he sued those two individuals. He has not focused on what they did wrong at all in this case. And finally, I think just the last thing in terms of sanctions. To the extent sanctions would have been appropriate during this case, I think the court should look at what's the purpose of the public records law and what are you trying to accomplish with sanctions. If it's purely penalty, then I'm not sure you're going to get very far, and my argument won't, but I don't think you'll get much in terms of changing conduct either. If the issue is to try and prospectively have an impact that increases a government entity's responsiveness to public records, then sanctions may be far more appropriate in terms of designing something that will achieve that objective. Sometimes in the ESI cases, courts will look at, in terms of sanctions, adopting new methods or new procedures or new software. In fact, in this case, the city took the step, which it had not taken for a long time for lack of money, of finally getting a software program that allows it now to take any public records request and within a few minutes, or certainly within half an hour, search every email in the city and copy it down. It couldn't do that when this case was filed. It now has the software to do it. That might have been an appropriate sanction, but I think the court should also consider that the city has continually tried to not only produce things, but is also trying to address the underlying problems. And part of that is getting a system whereby in the future they will be able to respond more quickly. IT now can go not into their individual personal account. It goes into a system that is set up by software to say, system, you go search for everything, and it will get everything. And then we won't have these problems that we'll deal with. And
Has it determined whether the documents Ms. Gavin, I think is the name, said she put on a table have been produced?
I'm not familiar with those documents yet.
Okay. I mean, it's got a system that's pretty quick and can go around. I'm just wondering if it's.
Oh, no, it will not do personal notes, paper
All right,
files.
I understand that. So are you arguing that I should vacate the sanction order that's already in place, much less not increase it?
I think if the court were inclined to sanctions, I think what would be appropriate is to vacate the existing sanctions and instead, although this is getting a little more complicated because Richard Miranda can't do anything. He retired last July. But maybe to the clerk to reinstitute procedures to reassert to city employees the importance of fully complying with requests for paper and calendars and other documents. And
How would
to
you respond?
advise.
How would you respond to two questions? That all these things that have been produced, these big productions, have very often been tied to motion practice, which Ms. Cruz has been billed for, and that therefore is an expansion of the litigation. That's one. And then I think on at least 3 occasions, perhaps more, you all have said you're paying for the sanctions anyway. That the sanctions are being paid for by the city and not by the clerk or the city manager, correct?
Correct. I'm not sure what the second question is.
Well, I just want to make sure that that position hasn't changed. Maybe I didn't phrase that well.
Yeah,
but
no, that position has not changed.
All right.
And what was the first question?
The first question is, hasn't the litigation been expanded based on this record unreasonably, because every time Ms. Cruz files something, litigates it hard, suddenly there are more documents produced? That's what it looks like.
And I don't believe that's true, Your Honor. I'll give one last exhibit, which deals with a claim by the plaintiff that the city produced that unattributed city proposal, that one sheet involving the Hector Martinez's deal points, so to speak. And the court can look at this later, but it goes through what the history is, and it starts with the production of it. Ms. Cruz has a supplemental PRR for that in September of 2013. It's produced a second time as part of the shared drive, and at that time had the metadata. And here again, nobody asked where is the metadata. It was there and available, and they could have certainly found it. But instead of that, plaintiff files another motion, and they attach to it that one page, and they say, this is unattributed. How can we possibly proceed? Because they're giving us unattributed documents. They had 2 or 3 prior explanations of that document. So no, it's not just the city's production that has expanded this. It's the plaintiff's insistence that any production is concealing something. Any new document is new regardless of whatever it is. Mr. Risner's Exhibit 3 that he just handed the court is something from May or June of 2013.
When was it produced?
That's when it was produced. It's either May 24th or June 21st, because I remember the email about Nicole's vacation. And now we're here saying we don't know the EIT. As the court pointed out, that's not the purpose of public records, to have you get verbal information, although the city's given that in this case. So no, I don't think you can just simply say because the two are going along concurrently that one necessarily causes the other or is a result of the other.
Thank you all very much for your time this afternoon.
Judge, if I could just respond to one thing.
Since you both have, I guess, technically they're your motions, Mr. Risner, so I'll give you the last word briefly. Go ahead.
Yeah, the city is a party. They filed an answer. You previously found that a city's a party in this case. I just clear on that.
All right, thank you for your time this afternoon. The matter's under advisement.
Thank you, Ron.
So,
Why do you think there's been the delay? Since you're ascribing to them intentional misconduct, why do
Yeah.
you think that's the case?
why is it in this case?
Yeah, why, I mean, you are ascribing to the city of Tucson and to Mr. McLaughlin and to others intentional misconduct.
Yeah.
And I assume that a lawyer of your experience doesn't do that lightly, so why don't you tell me why you think that's the case?
This proposal to sell the only public land ever sold was a massive crime in progress. The land is worth probably $75 million to $100 million. They had an appraisal where the city, Mr. Elias at the meeting, one of the exhibits here, where they need to arrive at the price at the highest level. Elias and Gottschalk are at a meeting. They decide in his handwriting $3 to $4.50 a square foot.
Okay, I read that.
The next day, then the Kaselemis goes to the office of the city real estate guy and says, we need an appraisal. The city has a process. They don't follow it. The appraiser is told, here's and we have the handwritten notes as to what comps to look at. And it said, we suggest you look at a comp that's 350, something like that. And it comes back and they pick the lowest value. And not only do they pick the lowest value, when you do the numbers ultimately, the city has a rule you can't offer a lease more than 5 years. And in 5 years, there's $7.3 million in taxes that aren't going to be paid. They offer a 50-year lease, which is $73 million plus in taxes that won't be paid. This property, the city, at the same time, they say we want a value for just plain dirt. There's pages of documents where the city says to grant, it's the greatest stuff ever. This more than 114 acres, but 101 they wanted to sell, is more than downtown Tucson itself. It's a tremendous piece of property. The school was going to use for their buildings maybe 8 acres, maybe 20 would be the most. And yet this was a whole 100-acre thing. It was a tremendous real estate development of a tremendously valuable piece of property, and the city cooperated in seeing that false information came in when they hired a woman in Phoenix to get certain numbers on how many students and would those live in dorms. She candidly said the records showed that there are very few students living there.
That's it, this BCAS deposition thing.
Well, I'm not sure. I think Kaselemis went into that originally.
But the number was changed.
Yeah, and the city says, and then she come back, she says, look, I'm changing it from 20% to 80% land. That's a big number, and that changes the numbers. And and I'm doing it on these other facts. When you look at everything down the line, all of those things, I look at the whole record and see what's there. And what's there was a massive violation of public policy. What's there was a huge heist in progress by individuals, each of whom has been promoted since then. And what's the roles of public people and public records? It's fair. It's a fair role. It's our system. that we get to look at these things and find out who was doing what, what's going on in terms of the public business. You know, that's what's gone on in this case. That's why they're hiding. That's why the city attorney stepped in to get these records and to deep sex them. And they played the system like a harp. That, I mean, you asked the question, that's the answer.
No, I asked the question, you gave it to me.
This is Scott Egan for AUDITAZ News.
Who was in charge of this project from the city manager's office?
Well, I believe that myself and Chris were the main people responsible.
But you were above him in the hierarchy.
Correct.
So were you the mainest guy responsible?
I was, yes, one of the people who was responsible.
What role did you play in the requesting an appraisal of the El Rio property?
I believe that I concurred with the real estate staff to prepare appraisal. Can't get it out. Prepare an appraisal. There you go.
Well, the city's required to have a market value appraisal, are they not?
Correct.
In fact, for projects this size, they would be required to have two appraisals, would they not?
Typically, yes.
And
sometimes even more.
And what would the appraisal be covering? What would it determine?
Well, the purpose of any appraisal would be to try to establish some basis of value for a piece of property. And that information could be used in a number of different ways, but the basic goal is to establish a basis for value.
And did you see the appraisal that was sent in this case?
I was aware of it, but I don't think I ever had possession of it, and I don't think I ever read it completely.
Yeah. And
I am aware it existed.
So are you aware that the appraiser was asked to assume a hypothetical condition and give an appraisal based on a hypothetical piece of property different from the condition of El Rio?
I don't believe I was involved in giving instructions to the appraiser. That would be something the real estate division typically does.
Yeah. Well, if the, well, let me just back up and just thank you for that, but if you'd answer the question, were you aware that they did not ask for a market appraisal, but simply asked for a hypothetical appraisal as if the El Rio property was a bare piece of dirt with nothing on it.
Well, yes, I was aware of that.
Yeah. Singleton and Lee. Are you aware of any written City of Tucson document that, for purposes of valuing that property, analyzes in any way the kinds of considerations that are discussed in number 13?
Well, I think the appraisal does acknowledge what the current use of the property is. And it states that the highest and best use of the subject property as if vacant is for future development with the mixed-use project. So that's what it says here.
Okay. Of course, it wasn't vacant.
Correct.
Yeah. Are you aware that if there's a request or if there's a lawsuit relating to records that a legal hold is placed on the records, are you familiar with that process?
No.
So you're not familiar with a public records requirement in Arizona law that if there's litigation concerning records, that while the litigation is pending, the records sought would be held and not destroyed?
No, I'm not aware of that.
Does the City of Tucson manager's office have rules about keeping notes of discussions?
Not that I'm aware of, no.
As far as you know, you indicated that you use an electronic calendar. Is that common within your office?
I can only speak for myself, but I assume others do that too.
Well, you've been there an awful long time to know whether others do that.
Yeah.
Objection.
So when you would agree it's common within the office?
Objection. You're instructed not to answer.
Are you aware of anyone who uses just a paper calendar to keep track of all their meetings instead of electronic?
I do not.
Are you aware? You don't know of anyone that does it then?
I do not.
Okay. And is within your management structure, is it common at notes that someone will take minutes at meetings?
No, I don't think that's common.
This is Scott Egan for AUDITAZ News. Here with attorney Bill Risner, who's been representing Cecilia Cruz in the El Rio Coalition. Bill, we just came from a court hearing, and can you tell me what you feel the result of this particular hearing has been so far?
Well, I have no idea what the result of the hearing is. The result of the hearing will be the judge's decision on three of the issues before him. One is whether he should reopen the case and permit us to
to obtain more proof from the city that would show what documents they've had, what documents were concealed by the city attorney's office. A second thing is what sanctions should be against the city, and primarily that is whether they should pay the full attorney's fees and cost. And the third thing is because the city has really drug this case out because of their behavior of lying and not turning over documents, whether the citizen, Cecilia Cruz, who's had to take untold hours and interfere with their life, and the statute says she gets damages if the city is wrongful, and they are wrongful, and the question is, and there's no real case that I can point to that's happened before, but in this case the real question is she should get her damages, and we want to proceed at this time with a damage claim.
Seems like during the court proceeding the judge was getting more and more angry at the City of Tucson and their lack of transparency and their attempts to kind of hide the records. Is that what you felt from the beginning with the judge, or do you think he's kind of seeing the light with the city?
I'm not sure what you mean by the beginning. From the beginning of the case, he thought the city had been, candid, and probably we were there politically with some motive. And that's pretty typical. The judges are part of a government structure, and they know when they deal with their people that they're honest, and so they think, gee, the city must be honest, and the city tells us they've turned everything over, so I guess it's true. But now, absolutely, he knows that they've lied to us, and it's human nature, of course. He's very offended that they've lied, really, to the court. I mean, of course, they've lied to him, but he's part of the court. He understands that among practicing lawyers, we have a certain basic set of professional rules. And one is you don't blatantly lie about facts to the judge. These kind of facts. You try to, I suppose, twist things, use terms of art to slide off stuff, this and that. You can. There's a certain range where we're, in court, and this case is one that I don't think I've ever seen in my practice, frankly. Nothing like it. You have an assistant city attorney where there's a huge volume of documents, key stuff, immediately get involved, immediately accumulate it, immediately have them give him those documents. And then he goes to court and tells the judge that they've turned everything over and all the documents are there when the key stuff has been hidden. For instance, when they told the judge that, there had been 140, I think, sheets of paper. Nothing more. It was something like that given to us. Since then, there have been 3,500 sheets of paper. And so the key stuff's been thrown in the trash can. The key stuff that he knew about and had in his possession. It's absolutely astonishing. And he's a city lawyer. There's no question that if I did that, I would have to look for a job. I couldn't be a lawyer anymore. It's that blatant.
This case has been going on for 2 years now, right? Since Cecilia Cruz made the request in May of 2013, right? In that whole time, the city lawyer has been McLaughlin. For 2 years, he's been defending the city, and for 2 years, he's been kind of fighting for the city's cause. All of a sudden, there's a new lawyer. He's sitting there in the case, but it almost seemed like he was in trial there. The judge seemed to be very angry about how many times the city has lied to him, or apparently lied to him. Do you think that that's a good thing, that McLaughlin is no longer the lead counsel on this, or what do you think that indicates?
Well, I anticipated when a different lawyer came in that was likely. When a judge finds that a lawyer has not been candid to him, then that sort of makes it hard to snooker him the second time. You kind of need a new lawyer. Plus, I think it's just the old principle. When you dug yourself in a hole, you try to stop digging. And the real problem was if, for instance, at this hearing today, the judge would ask questions of the attorney, who had lied to him, then all he could do was, basically lie again. So if there's another lawyer that says, yes, he may have been thinking of something else when he made that statement. Oh, there could be more facts. I mean, you don't want the same liar in front of you lying again. So they needed to bring in another lawyer, and they brought in a skilled lawyer. Mike McCoy's a very good lawyer.
One of the highlights, I thought, of this session here was at the very end, where the judge basically asked you, well, if the city has been violating the law by not providing public records requests, do you think that the city is covering up a bigger crime than just not providing public records as required by state law? You had quite an answer there, and could you maybe explain to our viewers here, summarize what you said to him about the cover-up and why the city would be covering up these for so many years, all these records?
Well, I thought that was a little interesting because ordinarily I couldn't stand up and really explain what I think the motive is here. It's really the facts of what have they done.
Right.
And I was taken aback, I suppose, a bit that, okay, you've asked the question, I can answer it.
You've opened the door.
you want the answer.
Right.
And the answer is this proposed sale of illegal was a major, huge crime in Providence. It was huge, and it involved a lot of people in the city. It involved a person who claims he's likely to be the next city manager, was in charge of that heist. And so I think, the public needs to know that information, but of course we don't have a media in Tucson except
us.
Yeah, so that's something you're never going to read in the Star or the Weekly. And what's today's date? The 5th, is it? 6th, okay.
March 6th.
March 6th, okay. I'm saying you're never going to read that. We'll see.
We will see. All right. This is Scott Egan for AUDITAZ News. This is Scott Egan for AUDITAZ News. I'm here with Cecilia Cruz Baldenegro in front of the Superior Court in Tucson. Cecilia, what do you think about today's court hearing?
Well, the lies continue, and it's very interesting that we had an attorney who was working on the case, and all of a sudden he's sitting almost as a defendant with another attorney answering questions that the judge is asking that Mr. McLaughlin, the original attorney, should know the answers to and knows the answers. Yet he asks him of Mr. McCory, who just came into this about, 6 months ago or something, and his response is of, well, I don't know. And this whole thing about, I find it very comical when the attorney for the city keeps saying that they've been transparent and they've produced records. The only reason that they've produced records is because we've asked them the records to produce. We've gone through the volumes, and how purposefully they have released documents is they'll release an email in 1 year and the attachment that goes with that email a following year. 2 years we've been on this, the following year. And yet they've been very transparent, that's what they're saying, and they chide us for not being able to ask them the right, what we want when they're doing this deception all along, and this lies and the deep sixing of information. And it is really just, I used to work for the city, and it's mind-boggling how this would be allowed, and that many of their records are no longer available. That's what we find. Oh, they've fallen off the computer edge of the world. Oh, you mean we could have stopped it? There is a way of stopping it so that they don't deep six, but we didn't do that with your case. All these things that you're finding out of what was done, that we're discovering, month by month by month, and the lie still keeps going. The city wants to be transparent. There's no transparency in this process, none whatsoever. And how they feel that they're going to take care of this issue is they've installed a new computer system, and that's at the sanction. Well, what about our lives? What about what is owed to the citizens of Tucson on the El Rio GCU deal that was such a farce and was really going to rip off citizens. That somehow is lost somewhere. Yet with the new computer system, or the systems really that they had before, they could have found that out. And they're just again lying that they can't. It's in the trash can. We'll pull it out of the trash can. You have the equipment to do it.
One of the things that I know the city attorney McLaughlin had said in the past, the judge had asked him, why is it that Channel 13 News asked for these public documents, you didn't give it to them. The Arizona Republic asked for these documents, you didn't give it to them. But you're giving some documents to Ceci Cruz. And McLaughlin's response at the time was, well, they didn't sue us for it. So do you think that's the city policy, that we're only going to follow state law as required to give out public documents if people sue the city to get what is they're legally allowed to do without having to go to court?
I think that has been so obvious to me in this case that that's probably exactly what they do. If you're not on the pieces of information that they release to you, and if they're using the city attorney for a supposedly client attorney privilege, and that person is getting all the documents and then identifying what they're going to release, I'm sure it is happening. And the way we found it out through the process is exactly by having to dig through, finding out what's going on, asking for information. And I'm sure that has been standard operating procedures for the city. And the only way you know is if you spend your energy, your time to get what they've given you and say, okay, they've given me this, but wait a minute, they didn't give me the attachment. Got another, you got to give me this. Oh, wait a minute, where's the second page to this? So I'm sure that's happened, and that's probably happened to a lot of people before me.
One of the things that I think the judge found incredulous, and I'm sure everyone else watching this did, was that people had said that they had given, the city employees had given the county attorney's office all of their files. And he had those files and lost all those files. And they also gave him computer chip, and he lost all of this. I mean, I don't think the judge believes that any more than we do. In fact, it seemed like the judge is getting pretty angry at being constantly told this nonsense, that files are just lost by the city.
Exactly, and I think it's very damning for a city attorney who really is in charge and to making these, that knows that, especially when he knows that a court is in court. McLaughlin knew, and so did everyone else, by May, the end of May, that this was going to court. And for them not to put a legal hold that states it very clearly in the city administrative directives that they are supposed to hold those records if they know a case is going to court, for them to say that it fell off the edge of the world, and for the attorney of the city working attorney, to say, I lost files. And how we know that possibly that file has been deep six is if one of the principals gave him a copy of Kaselemis' file because she produced it. It's on the record. Gave it to McLaughlin. McLaughlin then, in later conversation, says that he compared to make sure that Kaselemis' original file, not the copy he was given, but compared to see if they were the same. So we know then that Kaselemis had an original file, and the copy was made by a Camila to give to the attorney, Mr. McLaughlin. But now we have no record of both those files.
Poof. Just poof. It's
poof.
gone.
The copy and the original have poofed.
You've been at this for 2 years now. I know you've put a lot of time and a lot of energy and effort into this. Do you see a light at the end of the tunnel? Does it look like the judge is going to go your way, or do you have any predictions how soon there might be a new judgment?
Well, you know, I'm hopeful. I'm an optimist, that the courts are supposed to work for the people. The people, they're supposed to enforce the laws that people have to live by. And if this judge doesn't enforce the state laws on the statute about public records requests and the laws that the city attorney and the city have to follow, we're in big trouble. And I hear a little bit by what he's asking the questions, but he's asked these questions before. So there's where the pessimism comes in. Is he trying to give him an out? I don't know. I can only be hopeful. I've heard him say to the city attorney and that, you know, he doesn't say you lied, but that's actually what I hear, is that they haven't been forthcoming, they haven't been transparent, they've neglected this and that. So to me, it all says, you've been lying to me. We'll hold them accountable. if I were to lie to the judge, if my attorney would lie to the judge, we would be held accountable. I can
Right.
guarantee you that.
Sure, sure. Well, you know, as a resident of Barrio Hollywood, who lives right near that 114 acres of green public open space that they wanted to bulldoze, I want to thank you very much on behalf of everybody for what you've done. This is Scott Egan for Audit AZ News.